All right, y'all, it's a new year, and in the new year, I have made taking care of myself and my health a big priority. Trying to control my weight on top of having such a busy schedule has sometimes resulted in me eating overly processed meal replacements or heat and eat meals. Some of them may promote short-term weight loss, but it's not sustainable, and I know that I'm depriving my body of essential nutrients. They're often nutrient-poor meals that are made with cheap ingredients, chemicals, artificial preservatives, and additives. And there are GLP-1s that can be prescribed for weight loss, but medications can be costly and aren't always covered on insurance. Plus, they don't address the underlying causes of weight gain or teach you how to keep the weight off long term. They just rely on turning off the body's hunger signal, but that can end up preventing you from getting essential nutrients that your body needs and put you at risk for potentially dangerous side effects. Plus, you lose muscle along with the fat. But there's a healthier solution. Golo is a comprehensive weight loss solution that is safe, easy, and clinically proven to work. More than 5,000 doctors have recommended Golo to their patients. And by taking just 1 to 3 release capsules daily, you will quickly get control of your metabolic health within 30 days. Golo's Release is a natural supplement made of 7 plant-based ingredients and 3 key minerals that helps reverse insulin resistance, which speeds up the release of fat, and it naturally stimulates the GLP-1 hormone production to curb your appetite and balance blood sugar levels. My weight has fluctuated over the years, and there were times when I lost weight with some diet or trend, but I was really disappointed to gain it back. Golo can help with the underlying issues so you can keep off the weight. For a happier, healthier you, visit golo.com to get started on a more energetic version of yourself and enjoy 10% off. That's golo.com, code brandy10 for 10% off. Go to golo.com and use code brandy10 to join more than 5 million people who have switched to Golo as a better way to lose weight. Visit golo.com today.
The new developments in the Karen Read murder trial.
This has been a wild turn of events.
I've seen a lot of things. I've never seen anything like this. This case never ceases to amaze me.
It's a spectacle, that's for sure.
It was a hung jury, so no verdict, no real ending to this case.
Karen Read was back in court where a date was set for her to be tried once again.
There are a lot of issues in this case.
Proctor was improperly searching Karen Read's cell phone for nude photos.
Michael Proctor, the lead investigator,
relieved of his duties.
It's always the theories that each side will put forth for a jury to decide which one is more believable.
Karen Read was drunk and angry and hit and killed John O'Keefe when she gunned it in the snowstorm.
Karen, did you ever say I hit him? I did not.
There are more people here at the beginning of this than at the beginning of Johnny Depp's trial.
We're not concerned about any of the witnesses. None of the Commonwealth's witnesses are concerning us.
and once again there was drama outside court.
There is a whole new set of legal troubles for Karen Read. She is now facing a wrongful death lawsuit.
The lawsuit alleges that Karen Read was drunk and reckless when she hit John O'Keefe.
It's not just Read being sued here. The family also suing the 2 Canton bars from that night.
The 2 bars are liable for over-serving her.
The FBI is investigating an investigation of a murder. That never, ever happens.
At this point, multiple jurors have been reaching out to both sides, saying that they are certain Karen Read is not a killer.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
We're looking at arm injuries with scratches. We're not looking at tire tracks.
There are 17 jurors, and they are coming and going with a police escort.
The investigation wasn't thorough.
This can't be good for the prosecution moving forward.
I just hope justice is served for either one, whatever it is, you know.
The fate of her life is not in her hands anymore. It's not in the hands of her attorneys. It's not in the hands of the prosecutor. It's in the hands of the jury now.
I feel like we've gotten to the point where every week I keep repeating how crazy this case has become, and every week I'm surprised that this week was even crazier than the last. The hearing that ended abruptly last week caused a media frenzy fueled by false information and speculation. The hearing continued this week, and while there are some questions that were answered, there is still ongoing discussion about potential outcomes and possibilities of what the future holds for Karen Read's next trial and her defense team. We'll get to the hearing in just a bit, but we have a few other topics to cover first. First things first, let's go over some of the updates on the motions that were heard during the last hearing. Now, we went over these in episode 39, and Judge Canoni issued some rulings on February 24th. First up, the defense's motion about the video surveillance footage from Canton Police Department. Judge Canoni denied the defense's motion. She says that the Commonwealth has an obligation to provide the video that's in its possession, and she said she doesn't have anything that tells her that the metadata would be destroyed by doing it the way that Brennan wants to do it. So that's that. Brennan can click and drag, and the defense just gets what they get. Now, as far as adding attorney Mark Betterow to the defense team, Judge Canoni says that the affidavit from Yannetti is insufficient, and he will provide an additional one. So as of now, that motion is still just under advisement. The defense also asked for all chain of custody logs, reports, and evidence logs, and all of the other info to explain where all these random Sallyport clips are coming from. And Judge Canoni basically said that the Commonwealth can't provide what they don't have, so that's also denied. But the Commonwealth is supposed to turn over all evidence. They didn't do it the last time, but maybe this time they'll actually do that. I don't know, we'll see. But regardless, there's no chain of custody for any of this stuff and no way to determine who touched it, where they got it from, or whether or not it was altered or what else exists. Again, the defense just gets what they get and they don't pitch a fit. Now, the defense also asked for the information involving the witnesses in this case that are also involved in the Sandra Birchmore case. Now, Judge Canoni denied that request as well, saying that she doesn't have enough information to decide if it's beyond the scope of the Commonwealth's obligations under Rule 14, and whether or not the requested discovery is relevant, despite it all being about the credibility of all the same people. It's denied without prejudice, which means the defense can try to give more information to explain why it's relevant and see if maybe she'll approve it then. Judge Canoni denied the request for the internal affairs information on Proctor, the lead investigator in this case, saying that that's outside the scope of Rule 14, and she also denied their request for the communications between the experts and the Commonwealth, and the DA's office and any law enforcement that they communicated with. Now, this is the request that Ms. Little said was basically copied and pasted from the Commonwealth's request for communications between the defense and ARCA. But Judge Canoni denied it, saying that it's too broad. The only defense requests that were actually allowed by the judge are the specific ones that the Commonwealth and the defense already agreed on. Pretty wild. As we approach the second trial, we're getting a little bit of insight into how the Commonwealth's case will be different this time by the witnesses and the experts that Brennan is intending to call. Now, one of those witnesses is a man named Robert Gilman. Gilman is a meteorologist with more than 35 years' experience in media, business, and forecasting. Now, as part of his expertise, he apparently prepared a report that said that the typical lawn area at 34 Fairview would have been hard as a rock due to frost below and freezing of soil. Now, the problem with this is that a meteorologist isn't qualified to give an expert opinion on the hardness of the ground. As a reminder, here's ARCA expert Dr. Rentschler describing what it would actually take to give an opinion on how hard that ground would be.
Now, when you were talking about the injuries to the back of the head of Mr. O'Keefe, consistent with coming in contact with a hard surface, correct?
Yes, sir.
Would that hard surface include if the ground was frozen?
Well, you'd have to perform an analysis, actually, because you'd have to determine how hard that ground was. You'd have to look at the freeze and thaw cycle, probably leading up to weeks of that. You can't just look at ground and say, well, it's below freezing, so that ground must be frozen. I mean, is it a possibility? It may be, but you have to go through an actual analysis and procedure to determine how hard that ground is and whether it could have produced those injuries.
So it is something that's capable of being done by you, is that correct?
Performing that type of an analysis?
Yes.
You could go through and do it, sure, yeah.
And you didn't do it, correct?
No, I did not do it, no. Because, yeah, there's no need in this case. We don't know what happened in this case. There's no indication of certainly it's not consistent with getting hit by the car and ending up where he did, even if the ground is somehow hard enough to cause that type of an injury. Again, there's no movement and no force to get his body over there, and the damage with the car is inconsistent with him being struck by it. So whether the ground could cause it or not, the roadway could cause it, the curb could cause it, a back could cause it. There's numerous different possibilities, and we don't really have enough evidence in this case to determine what one specific event actually caused that injury.
This may seem like a small thing, but it's a big thing when part of the Commonwealth's theory is that the skull fracture that John O'Keefe suffered may have come from him hitting his head on the grass. Now, the case that is listed as an example here is one that has been cited multiple times in motions about expert testimony as we've prepped for this trial, and that is the case of Cara Rintala. I discussed this in episode 36. Basically, Rintala's wife, Anna Marie, was found strangled to death and covered in paint in their basement. The lead investigator said that rigor mortis had started to set in, but the paint that was spread all around Anna Marie was still wet. So they believed that Rintala strangled her wife and then sometime after that poured this paint all over her and all over the basement to cover up any trace evidence that could point back to her. Now, she was eventually charged, and her first 2 trials ended in hung juries. But the third trial ended in a conviction after the prosecution brought in an expert who testified about how long it takes for paint to dry. This convinced a jury that she had to have poured the paint after Anna Marie's murder. But the court overturned the verdict because they found that the expert's testimony about how long it takes paint to dry was unreliable since it was only based on past experience and not proper methodology and expertise. So the defense isn't wanting to completely exclude the meteorologist, just the part of his report and testimony about the ground being hard. This should be an easy decision based on case law and expert requirements. I expect him to be allowed to testify to the rest of his report, but just not give an opinion on the hardness of the ground. Now let's talk about the federal investigation for a minute. Now, Monday, February 24th, rumors started swirling when a couple of journalists reported that they had sources that told them that the U.S. Attorney's Office contacted state and local law enforcement the week before and let them know that the federal investigation in the Karen Read case had come to a close. And they said that something would be announced in court the following day at the hearing. My inbox went a little wild with people asking if this is true or what it could mean. So, spoiler alert, nobody announced anything in court about the federal investigation coming to a close. Not surprising. The Department of Justice has rules against the U.S. Attorney's Office being able to confirm or deny the existence of a federal investigation. This is the same answer that Josh Levy gave before Leah Foley took office. U.S. Attorney Foley was asked before these rumors started, and this is what she said.
I cannot confirm or deny if any investigation is pending, open, closed, or anything.
She was asked again this week after the rumors started, and this was her response.
So I'm bound by DOJ rules that prohibit me from confirming or denying the existence of a federal investigation. Yep. And that's just the rule. So I can't confirm. But I can say it would not be unusual for us to speak with our partners, our law enforcement to law enforcement partners about investigations.
Karen Read was asked outside of court this week about her thoughts on the rumors that the federal investigation was over, and she says that she has reason to believe the investigation is not closed.
I don't know that I believe that.
You don't believe it?
No, I do not. I have good reason not to.
You not believe that?
Yeah. Good work, Karen. From the horse's mouth.
So it's rare for the feds to announce that their investigation is over, but it's also important to remember that we don't even really know the scope of their investigation or who the specific target is. There were letters between the Commonwealth and federal authorities in 2023 that revealed that there was an investigation that involved witnesses from Karen Read's case, but the letters don't say who or what the investigation is specifically about. Norfolk District Attorney Michael Marcy called the federal investigation unprecedented and has speculated on why the investigation was started in the first place. One suggestion that he has given about why it started is that it was triggered by a complaint from Karen Read's defense team. Marcy also mentioned former U.S. Attorney Rachel Rollins, who he says made no secret of her animosity toward him when she was the Suffolk District Attorney. Now, Rollins ended up resigning from office after a 161-page report detailed a broad array of misconduct and ethical concerns. And Marcy suggested that similar ethics concerns could be at play with the federal investigation into the Karen Read case. Another suggestion seems to be that it was retaliation. So there was a woman who worked in Marcy's office as a prosecutor, and apparently her supervisors thought that she needed more seasoning and legal experience, so she was kind of demoted. She was told that she could get more trial experience in district court, so she resigned and filed an ethics complaint against Marcy's office. Now, this woman's husband is a federal prosecutor, so after all of this, Marcy's office ends up working with federal prosecutors, including the woman's husband, on an old murder case. Ironically, it was a murder case linked to Special Prosecutor Hank Brennan's former client, mob boss Whitey Bulger. Now, during this case, Marcy says the woman's husband asked a state police detective if he had any damaging information on Marcy or the DA's office. So, whatever the reason that started it, Marcy did not want the U.S. Attorney's Office for the District of Massachusetts handling the investigation, and he wrote in those letters that they must be removed. The request was denied because the Executive Office for the U.S. Attorneys found no basis for recusal. And actually, Jay Macklin, the General Counsel for the Executive Office, even said U.S. Attorney Josh Levy's office had a very different opinion of the circumstances in this case than Marcy presented in his letter. They hadn't determined at the time if any kind of prosecution was warranted yet, but they believed it was essential to continue their investigation. So we were never told the exact target or the scope or what they were looking into, but there has not been any kind of official confirmation that the federal investigation is over, or who the target of the investigation is. So we'll see what happens. We'll be right back after this. This message is sponsored by Greenlight. Who is it that taught you about money? Was it your parents? Did you learn it at school? Let's be honest, most of us learned about saving and budgeting way later than we should have. But there's good news. You can give your kids a head start with Greenlight. Greenlight is a debit card and money app made for families that lets kids learn how to save, how to invest, and how to spend their money wisely. Parents can send money to their kids and keep an eye on their kids' spending and saving. Meanwhile, kids and teenagers can build money confidence and skills in a fun, accessible way. For example, with games. The Greenlight app includes a chores feature where you can set up one-time or recurring chores, customized to whatever you do in your household, and you can reward the kids with an allowance for a job well done. I knew I wanted to give my teen a chance to learn good budgeting and spending habits way earlier than I learned it, and I'm so glad I did. If you're like me and you want to help your kids and your family develop those good habits and understand how to save money, now is the time to start using Greenlight. Greenlight is the easy, convenient way for parents to raise financially smart kids and families to navigate life together. Maybe that's why millions of parents and kids are learning about money on Greenlight already. Start your risk-free Greenlight trial today at greenlight.com/brandy. That's greenlight.com/brandy to get started. greenlight.com/brandy. Next up, the defense has filed their motion to dismiss due to extraordinary governmental misconduct. I was just about done with this episode when the defense's motion to dismiss the case based on extraordinary governmental misconduct was actually released to the public. So I stayed up late going through it so that we could have it included in this episode, since it's probably going to be a big part of discussion in the week to come. First thing, right there on page 1, there's a quote from a court ruling in Berger v. United States that pretty much starts this motion off. It reads, "A prosecutor may strike hard blows, but he is not at liberty to strike foul ones." It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. That is the basis of the issues that we've seen in this case so far. And that just became one of my new favorite legal quotes. Now, the motion to dismiss the case is based on repeated violations from the Commonwealth that have led to prejudice against Karen Read, according to the defense. Now, the prosecutors are supposed to be ethical, seeking justice and truth. They are not supposed to hide evidence, violate the defendant's rights, destroy evidence, present false information, or elicit testimony that they know is false. And they said they've done all of those things here. The motion says the Commonwealth altered the course of the first trial in this case by destroying exculpatory evidence, withholding exculpatory evidence, and interfering with the jury. And there's nothing that can remedy the serious constitutional and statutory violations other than dismissing the case entirely. So let's break each of these down. First, let's look at the destruction and withholding of the Canton Police Department video surveillance. Now, I've been over some of the arguments here before. The defense filed a motion to preserve all evidence, including all physical evidence, which would include the video footage. The motion was granted. Lally said he had no objection, so all of that video footage from Canton PD of Karen's car being brought in should have been preserved. But of course it wasn't. A few months later, there was another motion from the defense to get all crime scene pictures and videos taken in connection with this case. Now, the court ordered that the Commonwealth produce all video evidence and metadata associated with the videos on that date. So, all video evidence and metadata with all videos on January 29th is supposed to be turned over. So, how in the world did the court order the prosecution to turn over all videos and metadata in 2022, and now here it is in 2025, and they're still turning over videos, and none of it has metadata? How is that possible? What are the odds? So in October 2022, the Commonwealth is ordered to turn over all the videos they have, but they don't. So here's the breakdown of this. There are a total of at least 7 cameras and 8 video clips that are mentioned, right? Only 2 of them were turned over before the last trial started. Only 2 out of 8. Out of 8 clips, every single one that would show the condition of the taillight when it arrived is either missing or unable to be seen at the exact moment that the taillight comes into the frame. Every single one. What are the odds? Now, out of 8 clips, not even one of them has metadata or a chain of command or any sort of activity log associated with it. All 8 clips were in the possession of the Commonwealth or its agents for at least 2 years before they finally turned it over to the defense. Some they had for 3 years. That means that only 25% of the Canton Police Department footage turned over was not a discovery violation. But that's not the only issue. The video from the Sallyport front wall has 42 minutes missing at the precise time that Karen's SUV arrived and was brought in. Now, this would have shown a close-up of the condition of the SUV's right rear taillight when it arrived. It would show who has access to it and if anyone removed any taillight material before the first piece was discovered at 34 Fairview. That clip was turned over on April 4th of 2024, right before the first trial. The Commonwealth files their certificate of compliance, meaning that they are saying that they have turned over everything that they have to the defense. Everything we have, you have. We now know that's not true. So the trial begins and another video is turned over. This time, a video of the Sallyport that shows Karen's car coming in. Now, the video is inverted, and Sergeant Buchanan gets on the stand and tells the jury that it's an accurate representation and says, as you can see in the video, no law enforcement ever approaches the right rear taillight. Now we know, however, that Proctor did approach the right rear taillight. It only looked like the left because the video was inverted, and they didn't tell the jury that. The motion to dismiss says that this was an attempt to defraud the jury into believing that no one approached or touched or otherwise manipulated the taillight. And Lalley's questions, along with Buchanan's responses and the deliberate introduction of inaccurate evidence, was designed to perpetrate a fraud on the jury, the court, and the defendant. So, the trial ends, and suddenly, in October of this year, there are 4 more cameras and 4 more clips that are turned over. These are the clips that I mentioned in a previous episode that show Brian Higgins arriving to Canton PD not long after John's death, and he makes a phone call, which means he lied to the federal grand jury about not making any calls late that night. Now, this is considered exculpatory evidence, and it was withheld from the defense. This goes directly to the credibility of the Commonwealth's witness, and it wasn't even turned over until after the trial ended. And this isn't like it was just, oh, the police didn't give it to us, we didn't know. This video was in the possession of the district attorney during the last trial. But that's not all. In January of this year, 3 years to the day since Karen and John went to Waterfall to meet up with the Alberts and McCabe's, another video is handed over to the defense. January of this year. This one is of the SUV being brought into the Sallyport, and it appears to show an individual approaching the right rear taillight after the car is brought in. But, of course, the video is so grainy and blurry that you can't make out to see who it is or what condition it's in. Every single clip has a problem. What are the odds? The Commonwealth filed a response to the defense's motion to dismiss, and, not surprisingly, they dispute any ethical violations or misconduct, let alone misconduct that taints the legal system or infringes on the defendant's right to a fair trial. Now, when it comes to exculpatory evidence, which, keep in mind, is rightfully a very broad umbrella, the Commonwealth is basically saying, prove it. Prove it was exculpatory. It's a very frustrating argument. They try to focus on what they did turn over instead of what they didn't, and use that as proof of what condition the taillight was in. There's grainy dash cam video in the snow, photos that were taken later on, and reports of people describing the taillight being cracked, including the Dighton officer. But remember, that Dighton officer got on the stand and said that the taillight was not completely damaged. It was cracked and a piece was missing, but not completely damaged, which isn't what we see in the pictures from later on. There's also something in his response that he completely misrepresents, and it's also really frustrating. So Brennan says that the CERT team was already at 34 Fairview when Karen's car got to the Sallyport, and he listed evidence of the car's logs from Lieutenant O'Hara, who arrived at 4:56 p.m. at 34 Fairview, and then another trooper who had arrived 2 minutes before him. So yeah, that's half an hour before Karen's car got to the Sallyport at 5:30, and that's all true. But the reason that he's misrepresenting this is because of what he didn't say. O'Hara had testified that his last CERT team member didn't get to 34 Fairview until 5:41, which is 11 minutes after Karen's car arrived at the Sallyport. And at 5:33, when Karen's car had arrived at the Sallyport, there was still not clearance for the CERT team to start the search. Those are very important details. I mean, look, break down the timeline. Tully said that he went to Canton Police Department to wait for the CERT team members to show up so that they could go to Fairview. Karen's car arrives at Canton PD at 5:30 on the tow truck. It's taken off the truck, pulled into the Sallyport, where someone is seen on video walking over to the taillight area and then leaving. It's a 3 or 4 minute drive to 34 Fairview. It's only just a little over a mile away, and the last CERT team members get there at 5:41. Then, minutes later, they find the first piece of taillight. So that timeline adds up. And the point isn't that you have to believe this. The point is that it's possible, and it's reasonable, And if it's reasonable, that creates reasonable doubt. So any information that supports this theory would be exculpatory because it, quote, provides some significant aid to the defendant's case, end quote. But look, Brennan knows this. He knows the definition of exculpatory. He even put it in his own motion. He knows this. He's just trying to deflect. He doesn't want the court to focus on what they haven't turned over. He just wants to redirect the focus on anything that they did turn over, almost like they should be grateful. Something else that's alarming in here is that it says that the prosecutor is not aware of the existence of surveillance video in Canton PD's Sallyport until he saw the federal grand jury transcripts of Proctor. Now, you don't have to really be into law and order to understand what a big problem that is. They filed a certificate of compliance with their evidence, which states that they turned over everything there is after reasonable inquiry. But wouldn't reasonable inquiry include asking the lead detective if there's any more footage? So either the prosecutors utterly failed or the lead investigator hid evidence. Either way, this is bad. So the Sallyport video that was inverted, the motion says that the reason it came later is because Yannetti talked about the Canton surveillance video in a pretrial hearing, pointing out that they didn't have video of Karen's car entering. Well, that statement apparently ruffled Tully's feathers, so he reached out to Chief Rafferty, and she reviewed the video of the SUV arriving at Canton PD and told Tully that it does exist and they should have it despite what Yannetti said. And she's right. They should have it if it exists. So why didn't they? So she said that she would put it on a thumb drive for them in the event that they didn't have it. The prosecution said they didn't have it and didn't know it existed. So basically, they just keep finding out about evidence because of other people bringing it up. So the next batch of videos came because a certified forensic video tech from the DA's office looked at the footage, and it was so dark and hard to see that he went in and basically altered it to clarify it and give some other footage. Now, they also gave some footage from the same camera that inverted the Sallyport video. So that same camera showed an inverted video from like January 1st of 2022. They did that to show that the camera settings were set up to show it like that. Okay, and that's fine. But the problem there was that they didn't have any kind of explanation for it at trial. And more importantly, they didn't tell the jury it was inverted. In Brennan's response, he addressed the inverted Sallyport video, but Brennan basically says, yeah, we didn't tell them it was inverted, but after y'all called us out on it and then made a corrected version that was actually true and accurate, we played the whole thing, so don't be mad. Now, the October footage is also brought up. Apparently, that was created after the last trial because they wanted to, I guess, prove that Higgins really was moving his cars because of the storm. But what I don't understand is somehow they were able to create that to verify his story, even though it was way over 30 days. The Commonwealth's response says that that video was actually produced in August of last year with a letter from Chief Rafferty saying that it was produced in August. But it wasn't given to the defense until Brennan found it and was like, oh, oops, here you go, my bad. So if the video overwrites after 30 days, how did they create this video in August of last year? I hope that that's something that they can clear up because that leaves more questions. Now, Brennan said that the video that they just turned over in January is something that they had never seen before. It was placed in a physical case file and never given to the prosecution for download. Okay, but they had it, so it's not given to the prosecutor. It is there in the prosecutor's office. It's there with your people. How does that happen? Oops, my bad. Here's some more evidence that we had and didn't give you. The Commonwealth also says in their opposition that they have an expert who will show an accident reconstruction video that says that he does not think that Karen could have cracked her taillight by hitting John's car in the driveway. He says that this will be more proof that the condition of the taillight coming into the Sallyport doesn't matter, and therefore he shouldn't be held responsible for this video because it's not exculpatory. We'll be right back after this. This time of year, every cat is an indoor cat. And when it's freezing outside, I am also an indoor human. And if there's one thing that can really stink up being stuck inside, it's a litter box. Don't let that nasty smell ruin your winter wonderland. Switch to Pretty Litter like we did. Pretty Litter's non-clumping formula traps odor and moisture. It's ultra absorbent, it's lightweight, low dust, and one 6-pound bag works for up to a month. And Pretty Litter gives me peace of mind. It changes color to indicate early signs of potential illnesses in my cat, like urinary tract infections, kidney issues, and more. Since Pretty Litter ships free right to my door, I never run out, I don't have huge kitty litter bags taking up space, and I don't have to go out in the cold and lug those huge tubs from a store to my car and into my house. The cat litter that we were using before had to be scooped out a lot more often. It wasn't as absorbent, it left a dusty mess, and it did not trap odor the way that Pretty Litter does. Plus, I tend to be one of those fur moms that worries a lot about what's going on with our pets, so having the color indicators to warn me of early signs of health problems gives me peace of mind and makes me a little less neurotic when it comes to the cats. Ollie, Scout, and Champ seem to love it. Indoor cats and indoor humans agree. Pretty Litter helps my house smell fresh and clean. Go to prettylitter.com/brandy to save 20% on your first order and get a free cat toy. That's prettylitter.com/brandy to save 20% on your first order and get a free cat toy. prettylitter.com/brandy. Terms and conditions apply. See site for details. So back to the motion to dismiss. The next issue listed is withholding exculpatory statements made by seminal witness Jen McCabe. So here's the deal with this one. John O'Keefe is found on the Alberts lawn in the early morning hours of January 29th. Later that day, there's a text from Nicole Albert to Jen McCabe that says, "We'll get more info tomorrow. Don't want to text about it." Jen responds, "Right." So what's tomorrow? How will they get more info tomorrow? And why don't they want to text about it? So the defense sees this and they start kind of looking into January 30th. Now they have Jen McCabe's location information from her phone and they see that she's at this one address for almost an hour that day, about 45 minutes. Now they're able to figure out that that's Sergeant Lank's house. Lank is a longtime family friend of the Alberts and also the first law enforcement officer to go into 34 Fairview to talk to them that morning. So Jen McCabe goes to Sergeant Lank's home and it's not documented anywhere. There's no discussion about it anywhere, no reports, nothing. So now fast forward to the trial. On May 7th, the defense lets Lally know that they have Jen's location. They know that she was at Lank's house and they're going to use that as impeachment. Lally tells Tully. And 3 days later, there's a meeting with Jen McCabe and it's brought up that she was at Lank's. So now she knows that she's going to be asked this at trial. Now, when Jackson asks on the stand if she got any information the next day or did anything significant happen, then suddenly now she's prepared to answer and she says she stopped by Lank's. Now, Jackson probably automatically knew in that moment that she'd been prepped for this. So he asked her if she had any conversation before today with anybody about her going to Lank's house. And she says yes, a couple weeks ago at the DA's office.
I was asked, "Oh, were you at Michael Lank's on the 30th?
So Jackson begins asking Jen about this meeting. Jen says that the purpose of the meeting at the DA's office was just to let her know how this process was going to go. She asked what discovery had been turned in regarding her, and she just wanted to know what was coming. She says that it was her and her daughter, Allie, and they met with Tully and Miss McLaughlin from the DA's office, plus a couple of others, and Lieutenant Tully. Jackson asks what Lally showed her in relation to this meeting with Lank, and Jen says that Lally showed her nothing.
What did Mr. Lally show you in respect of this issue about this meeting at Michael Lank's house?
He showed me nothing.
He just told you about it?
Brian Tully told me.
Okay, what did Mr. Tully tell you, Trooper Tully? What exactly did he tell you at this meeting about this Michael Lank issue?
He said, did you go to Michael Lanks on January 30th? And at first I said, no, I've never been to his house. And then I thought about it and I said, oh my gosh, yes, I did go there. And that was the extent of the conversation.
Okay, so this whole conversation about the meeting specifically started because Jackson was asking Jen when she had been asked about going to Lank's house. So Jen starts listing the people that were there at the DA's office, including Lally. But then she changes midway through the conversation and says that Lally wasn't there. And she says that this was a different time.
Mr. Lally didn't have any follow-up questions?
I don't believe Mr. Lally was in the room.
Who else? I thought you said Mr. Lally, Ms. McLaughlin.
They were. They might not have been in the room at that time.
I see. So Mr. Lally just happened to, just saunter out?
It was a different time.
So Mr. Lally was in and out of the conversation?
Mr. Lally was not there when this conversation happened.
Well, why is that?
Because I met with Brian Tully and he was not there.
So now she's saying that she met with Brian Tully and Lally wasn't there. But just minutes before this, when she began describing the meeting where she was asked about Lank, she was asked specifically who was there and she gave this answer.
Mr. Lally, Miss McLaughlin, Steve Nelson, Trooper Brian Tully, I believe, and another woman, I can't remember her name, unfortunately.
Someone from the DA's office?
Yes.
That sounds like a pretty big meeting.
I wouldn't call it a big meeting. There was, 5 of them?
How long did you, 5 of them and then you? Right?
My daughter Allie came with me also.
Okay, so that confusion aside, at some point, Lally and McLaughlin told Lieutenant Tully about the impeachment information, and he talked to Jen McCabe about it before she testified. So what reason would Lieutenant Tully possibly have for meeting with Jen McCabe before trial? That's a lot different than a witness just meeting with lawyers before testifying. And he didn't write any report on this. No notes, nothing to memorialize it in any way, and it wasn't disclosed to the defense. Now, in the Commonwealth's response to all of the stuff with Jen McCabe, Brennan seems to completely miss the point, and he says that since the defense didn't call her back again as a witness during their case, that somehow that means that everything that they put in their motion doesn't matter. So, I don't know. That defies logic, but, that's nothing new here. So once this came out on the stand, then Tully wrote a report on it, but it wasn't written until a week after she testified about the meeting, and the report wasn't given to the defense until 2 weeks after she testified. Looking at the report, Tully says that it was Jen and her husband, Matt, who came up there for the meeting, but Jen said on the stand that it was her and her daughter, Allie. Also, the report says that Jen told Tully that she went to Lanks because they were picking up Carrie Roberts' daughter. But on the stand, she said that she went there to drop Carrie Roberts' daughter off. So, more inconsistent statements and another report that should have been created and should have been turned over to the defense. So basically, over and over and over, the Commonwealth did not provide the defense with exculpatory evidence. This is not a violation of discovery. These are also Brady violations. Now, that's a big deal. There have been cases that have been dismissed for way less than this. And think about it like this. There's not one charge that the jurors unanimously thought, yep, Karen Reed's guilty of that. All 3 counts. They either unanimously agreed that she was not guilty, like they unanimously agreed that she was not guilty of murder and of leaving the scene, or they were hung up. They were hung up on the lesser includeds. This isn't like a situation where everyone had enough information already to convict her anyway. This was a close call. This kind of evidence could have made a difference in whether or not the jury could have come to a unanimous decision. And speaking of the jury, that brings us to the next part of the motion. This is dealing with the jury, so it's heavily redacted, but they're alleging juror tampering. So the final part of the motion to dismiss alleges that Karen's Sixth Amendment right to an impartial jury was violated, and it talks about a juror being dismissed. Now, in last week's episode, I mentioned that Alan Jackson brought up a juror being dismissed minutes before his closing arguments. And it was a juror that he specifically said he believed was supportive of the defense based on body language and mannerisms while listening to testimony. I'm thinking that this may be the juror that's discussed in the motion. Now, the argument says a juror cannot be dismissed based on their views of the case or for reasons having to do with their relationships with other jurors. They can only be dismissed for reasons personal to the juror that have nothing to do with those views on the case or the relationships with jurors. Dismissing a juror because of their views is a violation of Sixth Amendment right to an impartial jury. There's case law cited that states what is supposed to happen if the judge thinks that there's some kind of juror misconduct. If she decides that whatever is happening raises a serious question of possible prejudice, then it says that she must hold a hearing to inquire further. Obviously, that wasn't done here. Now, I don't want to speculate too much on what this could be about, but something else that we recently heard is that Lieutenant John Fanning was apparently supervising the jury in the first trial. So here's the problem. Remember those disgusting texts that lead detective Trooper Proctor sent to the group chat when he said he was looking through Karen's phone and hadn't found any nude pictures yet? Well, those texts were sent to Buchanan, who is the one who testified about the inverted Sally Port video and said that it was accurate. And they were sent to Tully, who I just mentioned had a meeting with Jen McCabe that he didn't disclose and brought up her going to Lank's house before she testified. And they were also sent to Lieutenant Fanning. So an internal affairs investigation was opened to determine if Fanning failed to adequately supervise by not taking appropriate action after he got the text from Proctor, who is his subordinate. Now, Fanning was on vacation when those texts were sent, so he says that he didn't even see the text and didn't know that he was on the text thread until Proctor testified in court. Fanning wasn't a part of the investigation into John's death, but he's the supervisor for these guys. He's the executive officer of that unit. Now, the investigation into him was closed because they said that whatever they were able to look into, there wasn't enough evidence to prove or disprove that he was not supervising properly. Now, Fanning was also the lead detective into the investigation into the death of Sandra Birchmore. Fanning said in an affidavit that Sandra's death was a suicide based on physical evidence at the scene, personal notes discovered, and the medical determination. Obviously, we know that's not true. Another cop murdered Sandra and her unborn baby, and it took a federal investigation to bring that out. Fanning said that Farwell, who is now charged with Sandra's murder, told him that he broke things off with Sandra, told her that it was over and he was blocking her from all forms of communication. Fanning also handed over Sandra's laptop to Trooper Guarino, who, of course, also testified in Karen's trial about phone information. But Guarino somehow missed more than 30,000 texts between Farwell and Sandra that proved that he groomed her as a child, that he statutory raped her, and that also gave him enough evidence to lead to his arrest for her murder. How do you miss all that? But anyway, he's not really giving us much confidence in him at this point, right? But it's more than just us hearing about his terrible track record with supervising anything. It's more the point of he can't really be in charge of any kind of governing this jury or supervising this jury when one of his subordinates is the conflicted lead detective. That shouldn't be a thing. And the defense is saying that this was all kind of done right under their nose and they had no idea. There was a report from inside the courtroom that the juror who was dismissed right before closings, the one that Jackson said seemed very pro-defense, that she was dismissed because the judge was told that she was saying something about the case in a bar and it was overheard. Now, the juror was apparently not happy about this and denied the accusation, but she was dismissed regardless. Now, later that day, when it came time for deliberations, the other two, who were believed to have been the most supportive of the defense, were also dismissed. And the jury foreman was appointed directly by the judge. And the jury foreman is the one who told the other jurors that it was all or nothing and wouldn't write a note to the judge to find out if they could acquit on the murder charge and leaving the scene. What are the odds? There was a report from inside the courtroom that the juror who was dismissed right before closings, the one that Jackson said seemed like very pro-defense while listening to the evidence, was dismissed because Fanning allegedly told a court officer that the juror was at a bar drinking and talking about the case. Now, because the juror information is kept from the public, there's not a lot that we can know about this just yet, and there's not a lot that I can verify yet. Aiden Carney was inside the courtroom, and he's talked to a few jurors. He reported that Fanning is the one who reported this alleged video at a bar to a court officer, but said that the video was from weeks before. I guess the juror was not happy about this and denied the accusation, but was dismissed regardless. Later that day, when it came time for deliberations, the other two, who were believed to be the most supportive of the defense, were also dismissed as alternates. And the foreman was appointed directly by the judge and was the one who told the other jurors that it was all or nothing, and he wouldn't write a note to the judge to find out if they could acquit on the murder charge and leaving the scene. Again, what are the odds? In Brennan's opposition to the motion to dismiss, he addresses the jury tampering allegations. Brennan says this is patently false. He says that Fanning didn't have contact with the jury or have any influence over them. Brennan says that Fanning was working at the courthouse, but it was in the capacity of helping with peacekeeping efforts around the buffer zone, and he had no impact on the jury. He also says that there's no evidence that dismissal of the juror was improper. Now, again, the jury stuff is so secretive. All we can go on is he said, she said, because there's no way to officially verify anything. For that reason, I don't want to speculate too much on what did or did not happen. The truth has a way of coming out at some point. So, to sum all that up, the defense wants this case dismissed based on repeated violations and issues from the prosecution, and withholding evidence and alleged jury tampering, all that stuff. And Brennan's whole thing here is basically telling Karen Reed, prove it. Even though he's the one with the burden of proof, the entire response is him basically saying, prove that everything that we withheld would have benefited you. It's not really how this works. Kind of mind-blowing, but that's where we're at. We'll be right back after this. All right, y'all, it's a new year, and in the new year, I have made taking care of myself and my health a big priority. Trying to control my weight on top of having such a busy schedule has sometimes resulted in me eating overly processed meal replacements or heat and eat meals. Some of them may promote short-term weight loss, but it's not sustainable, and I know that I'm depriving my body of essential nutrients. They're often nutrient-poor meals that are made with cheap ingredients, chemicals, artificial preservatives, and additives. And there are GLP-1s that can be prescribed for weight loss, but medications can be costly and aren't always covered on insurance. Plus, they don't address the underlying causes of weight gain or teach you how to keep the weight off long term. They just rely on turning off the body's hunger signal, but that can end up preventing you from getting essential nutrients that your body needs and put you at risk for potentially dangerous side effects. Plus, you lose muscle along with the fat. But there's a healthier solution. Golo is a comprehensive weight loss solution that is safe, easy, and clinically proven to work. More than 5,000 doctors have recommended Golo to their patients. And by taking just 1 to 3 release capsules daily, you will quickly get control of your metabolic health within 30 days. Golo's Release is a natural supplement made of 7 plant-based ingredients and 3 key minerals that helps reverse insulin resistance, which speeds up the release of fat, and it naturally stimulates the GLP-1 hormone production to curb your appetite and balance blood sugar levels. My weight has fluctuated over the years, and there were times when I lost weight with some diet or trend, but I was really disappointed to gain it back. Golo can help with the underlying issues so you can keep off the weight. For a happier, healthier you, visit golo.com to get started on a more energetic version of yourself and enjoy 10% off. That's golo.com, code BRANDY10 for 10% off. Go to Golo.com and use code BRANDY10 to join more than 5 million people who have switched to Golo as a better way to lose weight. Visit GOLO.com today. So now let's get to the main event. The hearing that was held on Tuesday, February 25th, where the defense was allowed to address the accusations that prosecutor Hank Brennan made against them in court. Now, there are a few things that came out during the hearing that cleared up some confusion and a few things that we learned that we didn't know before. Defense attorney Robert Alessi is the one who argued for the defense, and he did a masterful job. He's a really great attorney. And I'll say this, if you listened to last week's episode, you'll know that a significant portion of Alessi's argument directly aligned with the arguments that I presented in that episode. Now, we're going to go over that and the rest of what happened, and you can decide what you think. Now, instead of going through the entire hearing and doing like a recap of who said what, I want to break this down into the main issues so that we can look at it more clearly. The hearing begins with Judge Canoni saying what her concerns are. Now, look, if we took things at face value for what Brennan said in court last week and how he presented it, and if what he said had been true, then I could understand the judge's concerns. Brennan made some big allegations, and it's wild to think that an attorney could get up in open court and do that. So I'm not going to give the judge a hard time for having a big reaction, because if those things had been true, they would deserve a big reaction. But now it's time for the defense to be able to address what Brennan said, what he misrepresented, and what he presented as fact that wasn't. And they get to clear some things up on the record. Alessi gets up with all the relevant pages in a binder with timelines and color-coded tabs, and anyone who knows me knows that is my love language. I wish he had made me one of those binders, but honestly, after all the research and effort that I put into this last week or two, I kind of already had my own for this anyway. Now, the first thing that Alessi does is address what he refers to as the moment. He's acknowledging that last week was wild. There were some big things that were said. There were some big accusations, and the judge had a big reaction. So he gets it. And he is here to work through this and clear it all up. So the first thing he does is go through the actual factual timeline. Now, Alessi is very concise when presenting this information. And as he walks through this, he also clears up a bunch of different misstatements, some wrong quotes, all of that stuff. Now, I'll say this. The judge suspending things for a week was a great thing for the defense because boy, is he prepared. So looking at the timeline, we know that ARCA did their report and issued that in February. Then Jackson discussed these findings that were in the report, which had been handed over to the Commonwealth and the defense at the same time. And he said in a hearing on March 12th that the ARCA reports concluded that the car did not hit John O'Keefe and John O'Keefe was not hit by the car. Full stop. That's their conclusions. Now, as independent witnesses that he had never spoken to, he had this result, so did the Commonwealth. Alessi says that the first email was sent to ARCA from Jackson on March 20th, which is after he gave those conclusions in open court on the record. Jackson did what any normal defense attorney would do. He contacted this expert and asked them to testify, and he brought up the engagement letter and the retainer that would be necessary for that. But this isn't like any other trial because of the federal investigation. So Dr. Wolf responded that they needed to pause discussions and wait to hear from the U.S. Attorney's Office about how to proceed since this is a weird situation. There's a federal investigation and a protective order, and this isn't like every other trial procedure that they would normally do. So here's something that's very important here. The limits that were put on talking to the ARCA experts were put in place by the U.S. Attorney's Office, not by this court. So the defense isn't going into this knowing what those limitations are. They don't know. Now, there seems to be a lot of confusion about what the restrictions are from everybody, from the defense, from the Commonwealth, from the judge even. It's not that the feds are like, oh, heck no, you are not allowed to talk to anyone that we hired. It's not about that. What it boils down to is that they hired this company to do testing and come to a specific conclusion to assist in their own investigation. That's now part of their evidence. You want to use it? Sure, go ahead. You want to have them explain to you what they're explaining to us and give you the results too? Sure, go ahead. But you can't engage with them in a way that now messes up anything that we have going on over here. You can't elicit more answers from them or ask for additional testing or basically do anything that's going to cause us problems in our investigation. The feds have limits because this is their investigation resources. So ARCA can only testify to what they're also testifying to in the federal grand jury. That's why they had to turn over their report. Makes sense, right? So sending an email trying to engage an expert when you don't know what those limitations are is going to be completely normal. There's no issue here. So Jackson calls and says he wants to have them come testify. He sees this great report that supports everything he's been saying, and he wants them to come testify. And then he follows up with an email so that he has everything documented. He mentions the phone call from that morning, nothing to hide. He mentions it in the email, and he tells Dr. Wolf to let him know about an engagement letter and a retainer as required, because he doesn't know what's required. This is unprecedented stuff going on here. That's why that language is important, because he wrote as required because he doesn't know what's required. This is new territory, working with an expert who was hired by another government entity than the one that you're up against. So he doesn't know what's required. This is his first time reaching out, and he's trying to get this set up so that he can have these witnesses testify. He also asked for a copy of the CVs of Dr. Wolf, Dr. Rentschler, and Mr. Klein, the three who were listed on the report. Now, he thanked him. He said he looked forward to ironing out logistics here. So there's no promise of anything at this point, just an initial contact and a plan of trying to figure this thing out as we go. But that came to a halt because Dr. Wolf responds 2 days later and says that they need to pause until they receive more information on their involvement moving forward. So now the defense has these great witnesses that they don't even know if they're going to be able to use because they were told that they have to pause everything. Now, Alessi also points out that when Yannetti did the openings, he didn't mention ARCA at all. And here's why that matters. If you have an independent third party, these highly credentialed and qualified experts who you didn't even have to hire, and you know they're going to come in here and tell the jury that there's no way that Karen hit John with a car, that's something you're going to tell the jury in openings because you're going to want them to know that's coming. You're going to want them to hear that. And Yannetti not mentioning them shows that there was no agreement in place because everything had been put on pause and they didn't even know yet if ARCA would be able to come in and testify. So April 29th, opening statements, right? Now the trial has begun and the clock is ticking and the defense still isn't sure about their limitations here or what they can do or what they can do to get ARCA up there. Now the openings were on a Monday and there was no court on Wednesday. So that Wednesday, Jackson called ARCA again, hoping to end this pause where they're waiting on the USAO and get the ball rolling again. They're on a time crunch here. Now, they still have the ARCA witnesses on the witness list, and as trial is moving on, the Commonwealth is getting close to being done with their case, and it's going to be time for the defense's case soon. So Lally brings up the Rule 14 issues where he doesn't have the info that he needs from ARCA to get whatever he needs in order to be able to effectively cross-examine them. So Jackson contacts ARCA again, trying to see if there's a way to get logistics worked out, see if they could do possibly a voir dire, which would remedy the situation. So that's brought up the next morning on June 10th. And Yannetti tells the judge that they haven't met their Rule 14 obligations because they can't. So here's something that's also very important here. Yannetti says to the judge that the federal protective order that limits what they can say and do with ARCA prevents them from being able to do any kind of trial prep. Now, Alessi says this isn't actually accurate. Remember, they still don't know the details of what's allowed and what's not at this point. And Yannetti said that, believing that it was true. But Alessi says that the order actually only limited any kind of substance conversations about ARCA's testing or their findings. Now, this is really important because of all of those allegations that Brennan made against the defense last week. There are rules of professional conduct for attorneys, and Brennan got up there and spent his whole speech building up the narrative that the defense was hiding information from the Commonwealth and the court, and that they had to find all of this out through the feds, and that Jackson and Yannetti violated their code of ethics. All of these things are huge allegations, and this was made in open court by giving a lot of speculation and a lot of wrong information. So Alessi is making sure to be very clear on these points to show that Brennan's claims are baseless. So the judge decides that they can do this voir dire for the crash daddies in the first trial, right? So it's scheduled for June 18th. Now, the day before, the ARCA experts spend some time getting everything together for this. Remember, at this point, it's been more than 4 months since they finished their report on this. So going into a courtroom the following day to answer detailed questions about your testing would obviously require some time prep. So it's not surprising that they did this. The experts are keeping up with this time. They don't work for free. They got paid to do their research and their testing and make their report by the U.S. Attorney's Office. And then the defense tried to hire them, but they were told to hold up on that until they figure out how to proceed. But crash daddies aren't free, y'all. So regardless of how this gets worked out for payment, they're going to keep up with the same things that they keep up with for every trial that they testify at. And they're going to keep a timesheet and an expense report. This is standard for any expert. And we know that they've both testified enough to know this. This ain't their first rodeo. This might be the first time they've had to deal with a state case and a federal case and have that part to work out, but this is not their first time testifying, so of course they're going to keep up with all of that. So voir dire happens on the 18th, and each side has the chance to ask any questions that they want to without limitations. The nighttime visibility factor is brought up. I played those clips and we went over all of that last week, so I'm not going to go back over that, but Alessi went over basically everything that I made in the episode last week. He went over those same things and played those same clips. Now, the nighttime visibility thing is also on Dr. Wolf's CV that you can download from ARCA. It's brought up in voir dire, and Jackson brings it up and specifically asks about it during the direct examination. So if this is any kind of shh, don't tell kind of secret, it's literally the worst kept secret of all time. So Alessi points out all of that. Now, the ARCA experts are scheduled to testify on a Monday. Normally, when experts testify, they get to prep with the lawyers. Now, there are rules and regulations about how questions can be asked in court. This isn't a situation where Dr. Wolf gets to just get up there and say, hey, y'all, guess what? I built a cannon, and describe how he did it. I still love the whole canon thing. But there's a way that lawyers have to ask questions, and there's a way that witnesses have to answer them. Experts are there to give insight into things that a regular person doesn't understand, right? And if a regular person doesn't understand, then a regular person might also not know what questions to ask to get them to be able to explain what they're there to explain. Now, think about it like this. If you have a phone data expert, for example, and they're there to testify about location information, and all you have is a report with a ton of coordinates, an attorney might not know what questions to ask to get them to be able to explain where this came from, how accurate it is, what do they know from it, how do they know that, why can we trust what they're saying? What about that one time that we watched Law & Order SVU and they said something different? These are all things that the jury needs to hear, and that's why the experts are there. So coming up with an outline of questions and answers is common. This is nothing new. The attorney knows the destination, the expert is driving the train, but an outline of questions and answers is basically just telling the attorney where to lay the track. It does not change the results. It does not change the opinions. It just helps them both get there. So a lot of times these outlines are done and the attorneys and experts are able to discuss them together. But of course, this situation is different. It's pretty much unheard of for a federal investigation to be happening at the same time as a state prosecution. So again, we are in new territory for everyone involved. Jackson has an incredible knowledge of physics and science. And you can tell by the way that he questioned Trooper Paul during cross-examination and the way that he questioned the ARCA experts during voir dire and their testimony. So the key component of the defense is that the car did not hit John O'Keefe, and John O'Keefe was not hit by the car. Jackson spent a ton of time prepping for the questions that he was going to ask these ARCA experts. This isn't a situation where he was just going to get up there and wing it or wait till the last minute and throw something together. The core of the defense is this, and Jackson went into this extremely prepared. Now, having said that, Dr. Wolf maybe didn't have as much time to prepare for all of that. Sure, he did the work and he did the report back in February. But when it comes to being on the stand in a courtroom getting asked a bunch of questions, he didn't get to prep the way he's maybe used to. Dr. Wolf emailed Alan Jackson an outline of questions and answers, letting him know that he didn't give verbatim answers, of course, just general responses that kind of get the point across. Now, the Q&A outline had questions that were discussed in voir dire, conclusions from their report that were turned over in February, and information about their qualifications and background. All of the stuff that's on there is not new stuff. Both sides had access to all of that information. So Dr. Wolf told Jackson, feel free to change whatever he needs to. Now, I want to be very clear on this part. If you've tuned me out, start paying attention now. Brennan made a big deal in court about this. He wanted to spark outrage. He's not dumb. He's a defense attorney, and he's actually prosecuting this case like a defense attorney. Any defense attorney knows that it is common for an expert witness to have an outline of questions and answers as a guide for the stand. Saying, feel free to change whatever you want, is not an offer to alter testimony to whatever the defense desires. That's an expert witness letting the attorney who is calling him to the stand know he acknowledges that this is his list of questions and answers based on what he's there to testify about and his research, and there are some things that may be irrelevant or outside the scope of what they're being called for, whatever. For example, if anything is in there about the head injuries, the ARCA experts weren't allowed to testify to that in court. Feel free to remove things that aren't allowed. Feel free to change whatever you want from this guide because since we can't prep the way that I'm used to, I don't really know exactly what you need. Saying feel free to change whatever you want is about the line of questioning. No matter what Jackson would have wanted to change, there would be no way for him to change a report that was written more than 4 months earlier and handed over to the prosecution at the same time as the defense. And the federal government had it. Period. And Brennan knows that. That stunt that he pulled in court was intentional. Brennan said, it's not their opinions that concern him. It's the relationship. Think about that for a minute. Brennan says he isn't concerned with their opinions because he doesn't want anyone to focus on their opinions. He knows that their opinions were in cement before the defense even knew who ARCA was. Brennan knows he can't argue with that. So, what can he do to try to discredit the most credible witnesses? The ones that are the worst for his case? Well, he can try to use speculation, innuendos, false information, and a theatrical presentation to give the appearance of impropriety, and just hope that people don't fact-check him. Good thing I like to fact-check. Brennan's misrepresentations sparked a social media firestorm where unhinged, self-righteous keyboard bullies felt entitled to try to destroy someone's life. The ARCA witnesses have been accused of being paid off by the defense. They've been doxxed. Their families, wives, and children posted all over social media. People have attacked them online and given out ARCA email addresses, encouraging others to write to ARCA and demand their termination. Brennan wanted to discredit the two most credible witnesses because they were bad for his case, and he attempted to do it in the dirtiest way possible. One thing I've learned is that if your argument is strong, it can speak for itself. Think about it in terms of extremes. If someone comes along as you're sitting on a park bench and they tell you the sky isn't blue, it's red, how much effort are you going to put into arguing with them? Not a lot. Their argument is nonsense. You know the truth. You can see that the sky is blue. Maybe they have some reason for seeing it the way that they do, but that's their reason. It doesn't change the truth or what you know, so why argue? You don't need to attack them. You don't need to attack anything about them. You have the truth. But some arguments aren't strong enough to speak for themselves, and that's often when personal attacks begin. Attacking these federal witnesses and their families isn't going to somehow change their opinions or conclusions, and it's definitely not going to impact their reputation. ARCA is trusted by the federal government, local government agencies, the U.S. military, NASA, SpaceX, FEMA, National Hockey League, and so many others. But there are right fighters who need for ARCA to somehow stop being credible so that they can be right. And Brennan is one of them. We'll be right back after this. All right, y'all, it's a new year, and in the new year, I have made taking care of myself and my health a big priority. Trying to control my weight on top of having such a busy schedule has sometimes resulted in me eating overly processed meal replacements or heat and eat meals. Some of them may promote short-term weight loss, but it's not sustainable, and I know that I'm depriving my body of essential nutrients. They're often nutrient-poor meals that are made with cheap ingredients, chemicals, artificial preservatives, and additives. And there are GLP-1s that can be prescribed for weight loss, but medications can be costly and aren't always covered on insurance. Plus, they don't address the underlying causes of weight gain or teach you how to keep the weight off long term. They just rely on turning off the body's hunger signal, but that can end up preventing you from getting essential nutrients that your body needs and put you at risk for potentially dangerous side effects. Plus, you lose muscle along with the fat. But there's a healthier solution. Golo is a comprehensive weight loss solution that is safe, easy, and clinically proven to work. More than 5,000 doctors have recommended Golo to their patients. And by taking just 1 to 3 release capsules daily, you will quickly get control of your metabolic health within 30 days. Golo's Release is a natural supplement made of 7 plant-based ingredients and 3 key minerals that helps reverse insulin resistance, which speeds up the release of fat, and it naturally stimulates the GLP-1 hormone production to curb your appetite and balance blood sugar levels. My weight has fluctuated over the years, and there were times when I lost weight with some diet or trend, but I was really disappointed to gain it back. Golo can help with the underlying issues so you can keep off the weight. For a happier, healthier you, visit golo.com to get started on a more energetic version of yourself and enjoy 10% off. That's golo.com, code brandy10 for 10% off. Go to golo.com and use code brandy10 to join more than 5 million people who have switched to Golo as a better way to lose weight. Visit golo.com today. The outline that Dr. Wolf wrote was sent out around 3 p.m. Sunday afternoon, long after Jackson had already planned out his questions for the ARCA experts. He wasn't waiting on that timeline to know what to ask. Even the judge acknowledged that nobody thinks that. Well, at least not anyone logical. Now, Dr. Wolf put that together and sent it Sunday afternoon, and Monday morning he was on the stand. The key points about the timeline are this. ARCA was hired by the federal government to determine what possible interaction could have occurred between John O'Keefe and the Lexus SUV. They did their testing, made their conclusions, and gave those to the federal government, who then shared it with the prosecution and the defense at the same time. Those conclusions were very specific and cannot be altered after the fact. The feds have the same report. You think they're going to change it up and have to explain that to the Department of Justice? No, use common sense. The report is done, conclusions are set in stone. The defense tried to hire them, was told that it's a Fed thing, so they needed to pause and figure out how to move forward. They were able to voir dire and testify to the same findings that they gave the feds, and that's that. One of Judge Cannoni's concerns that Brennan brought up in the last hearing is the invoice from ARCA.
And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid.
Alessi also addresses the invoice. We can see in the discovery that it was turned over that the defense tried to hire ARCA said that they can send retainer as required, and wanted to know how to move forward. They were told that they couldn't move forward, they had to pause. Nothing else was ever said about it in any email communication. So the trial ends, and on July 12th, ARCA creates an invoice. It's sent to Jackson's office. Alessi says that this is something that the defense wasn't expecting. It kind of came out of the blue. They had no idea that they were being invoiced because after their offer to engage ARCA, there were never any agreements, nothing was signed, they were just told to pause, and it was never mentioned again. They don't have a problem paying it. I mean, look, they wouldn't have tried to hire them last March if it was a problem. But again, we are in uncharted territory here, and they didn't know what the expectations were. So Alessi says that they called the U.S. Attorney's Office.
The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing? Mr. Deitch said, yes, you can pay it.
The U.S. Attorney's Office says, yep, you could pay it, no issues there. So Jackson's firm cuts a check, pays the invoice, and all of this was done after the trial. So now it becomes discovery for this trial, which is why they turned it in along with the rest of the ARCA discovery. It was for this trial. Now, Jackson asked the ARCA experts on the stand. It goes without saying, but I haven't paid y'all anything, right? And that was the truth. There was no promise of retainer or payment. There was an inquiry, but there was never a promise or agreement. There were no violations made there. Brennan doubles down when he gets up to address this again.
It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. When I'd suggest more 3.6 activity, quote, no, of course not. That was the position last week.
Did you pay the ARCA experts to testify in the first trial?
No, of course not.
Not surprisingly, this is once again a huge misrepresentation of what was said. Christina Rex did not ask if Jackson paid the bill. She asked if Jackson paid the ARCA experts to testify in the first trial. If Jackson had paid ARCA to testify in the first trial, that would mean that he and Dr. Wolf would have been lying when they both confirmed that the defense had not paid them. That distinction matters. Those are two very different questions. And here's Brennan, once again, misquoting and misrepresenting statements in order to manipulate the court and the public. Maybe if Brennan would spend less time on Twitter and more time watching the first trial, some of these misrepresentations could be cleared up. As Alessi walked through all of the information, he listed out 10 misrepresentations and misdirections that Brennan used last week to build up to this huge moment that Alessi had mentioned when he first started his arguments. The entire buildup of what happened during and after that hearing was on the false statement Brennan gave that the Commonwealth had gotten all of their information from the federal government and not the defense. So what happens? Media is flooded with the judge's statements of grave concerns about the defense. Her reaction goes viral, just as jury notices are being sent out in the mail. The viral reaction that was incited through wrong information that was given to her by Brennan. The email that Dr. Wolf sent with the qualifications clearly shows an attachment that's labeled. Brennan 100% misrepresented that to the judge, claiming that he didn't know when it was from because he got it from the feds, which, of course, we know wasn't true. And he could have seen where it was from if he looked a little closer at the emails that he was reading in court while making his accusations. Brennan said that they didn't have adequate discovery, but they did have all the stuff that they were saying that they didn't have during that hearing. And they had had it for 5 days. They got it from the defense. He goes through all the dramatics of how he thought that there must be more to the story, so he called the feds and got discovery. He built the entire moment on the foundation of the defense hiding things that the feds had then turned over. And it blew up because it was all fake news. So when Alessi was up giving his arguments, he said something about Dr. Wolf writing out the outline of questions and answers because he was a little nervous about testifying without being able to prep the way that they normally prep for trial. Now, the judge told Alessi, do not speculate, which is fine. We don't want speculation in court. But then Brennan gets up to give his rebuttal to all of this. And not only does he double down on all of the misrepresentations and allegations that he made, but he spends his entire time speculating. Brennan speculates that there must have been or could have been more communication between ARCA and the defense in those large gaps of time where there weren't any communications that were turned over. Brennan speculates that the defense only turned over their discovery because of the federal information being turned over. Brennan speculates that the defense only called 2 of 3 of the ARC witnesses because they must have had more conversations about what they did and who helps the defense's case. Brennan speculates about conversations between the defense and ARCA to prep for trial. Now, he does finally say that he misspoke, but he says he corrected it. Then he says it's not the source of that information, it's the substance. Although we spent all of the last hearing watching him make a huge production over the source of that information, not knowing that he was wrong. So what are the main issues here? Rule 14 obligations is one of them. Those emails that were sent the weekend before the experts testified should have been turned over to the Commonwealth. In a perfect world, it would have been turned over, no problems. But when they come in hours before the witness takes the stand, and the attorney isn't using it because he's already made his own outline anyway, and it's the end of June, and they've been in a busy and exhausting trial for 2 months now, it's really not surprising that they didn't get turned over. Now, does that create some kind of prejudice? Well, let's use Brennan's own arguments against him. Brennan said that it doesn't matter that they didn't turn over all of the Sallyport video clips for the first trial because he says that they're grainy anyway, and they don't give any substantial information. Well, the ARCA outline is all full of stuff that was already in the report that they had access to, so that didn't give any substantial information. Brennan says that the defense may have turned over all of that for this trial, but he says that they didn't have it for the first one. So is that prejudicial? Well, I would guess not, since Brennan's argument about the Sallyport clips is that they are still turning them over, and it doesn't matter because the remedy for a Rule 14 violation in the last trial is that they have it now, so it's over and done. Now, Brennan made us sit through 2 days of Daubert hearings for Dr. Russell because he said that this is a new trial. So, yes, the emails are a discovery issue. One of many, many discovery issues from the last trial. There were issues from both sides constantly. Now, it's an oversight, and it has been remedied, and now there's nothing else to do for that. Brennan said that he's not trying to deprive Karen Reed of the ARCA experts. He actually said that 5 times. I would be shocked if the judge excludes their exculpatory testimony. But obviously, all of the things that were brought up here will be brought up by Brennan on cross to try to discredit their testimony to the jury. Now, the other big issue here is the implications of ethical misconduct by the defense attorneys. There was a big buildup about being surprised at trial, about not having all of the information and all of that. So if you compare the outline that Wolf made to what Jackson used when he was on the stand, Alessi points out that it's not similar. So it's obvious that Jackson did not use it, and he also didn't create it. And he's the one who specifically elicited the testimony about nighttime visibility factors. So the dramatic, shh, don't tell them moment has nothing to do with Jackson or anything that he did. So there's no ethical issue there. Every statement that was made by Yannetti and by Jackson about ARCA was said in good faith based on the knowledge and understanding that they had at the time. Now, the division of responsibilities for attorneys, especially in a trial that's this long, that's not surprising. And they were honest when they elicited the testimony from ARCA that they haven't been paid anything. The defense didn't hire them, and ARCA doesn't work for them. All of those things were true. There was no engagement or retainer. Nothing was ever agreed on or signed because the March email put all of that on pause, and it was never re-engaged. Now, one of Judge Cannoni's biggest concerns, she said, was the sidebar with Alan Jackson on February 6th, less than a week before the ARCA discovery was turned over for this trial.
what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me.
Jackson says that although they had not yet turned over the discovery with the emails that would be turned over days later, when he made this statement, he did not willfully mislead the court because the conversation was specifically in context of the federal TUI requests.
Same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making a comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I did as well after I
no,
looked at the transcript.
I did long before I looked at the transcript.
Right. The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we refer to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment?
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Prosecutors are supposed to seek truth and justice. Their obligation ethically is to the truth. Defense attorneys have an ethical obligation to their client, but either way, each side has ethical obligations, and those are taken very seriously. So, we'll see what the judge says about all of this next week. So what's next? The Commonwealth is still turning over discovery to the defense. The defense was informed late afternoon on Wednesday the 26th that Brennan has additional discovery to turn over, including chain of custody reports related to the Sallyport videos. Now, that's interesting considering he argued in court that those don't exist. But apparently he's having the retired sergeant make a report on it, but he isn't sure how long that will take. I'm assuming it would probably just have to be him asking people and them writing a report on what they know about it. So time will tell. They're supposed to be handed over by Friday morning, the 28th. Now, Brennan also recently told the defense that they are going to be handing over more Sallyport videos. These were said to have been stored on the department's video file system, but it's unclear if those videos will be duplicates of what they have or if there will be new material. But these aren't even expected to be handed over until March 3rd. So based on this, the defense will probably be filing a supplement to the motion to dismiss. The defense has asked for the scheduling dates to be shifted around to give some more time since the Commonwealth is still turning over discovery. These videos won't be given to the defense until March 3rd, and the motion to dismiss is supposed to be argued the next day. But the Commonwealth opposes shifting the schedule around too. They want to be able to do whatever they want, and they have zero concern for the defendant's rights. And I stand by that. My name is Brandy Churchwell, creator of 13th Juror Podcast. If you're enjoying it, please leave us a review on Apple Podcasts and Spotify, and share this episode with your friends. For more information, photos, and episode guides, visit our website at 13thjurorpodcast.com.